Welcome back to this third segment of this public law session on sources of the Constitution. Immediately before the break, of course, we were looking at conventions. We started a discussion on that, and certainly I said to you before the break, immediately as we come back, we will talk about Mazimbamuta and Lardner Burke. So let's go straight ahead and look at that. Well, in the Mazimbamuta and Lardner Burke case, the court said that there was a convention that the UK, well, in the case anyway, the convention that was being considered was that the UK would not legislate for the then Rhodesia without the colony's consent. So that's the convention. General rule, convention is the UK will not legislate for a colony without its consent. In the case, however, this did not stop the UK Parliament from legislating in breach, arguably, of the convention if it chooses. Remember, go back to parliamentary sovereignty. Parliament can legislate on anything it likes. Now, we'll talk about the case a little for public law purposes, because this is the kind of case that, for those of you doing jurisprudence, you will have to come back and delve into it in some more detail. But let's look at what the case itself brought about. Well, the case arose in a situation in relation to Rhodesia, as Zimbabwe was known then, and it was in the context of the Unilateral Declaration of Independence. We'll call it the UDI. The Smith government at the time, in November of '65, declared this Unilateral Declaration of Independence. Now, the case went through 3 courts and 7 judgments. Very protracted, very long. And in essence, what happened in the case was that Mr. Mazimbamuta was a nationalist. He was fighting with others for majority rule. Mr. Lardner Burke, of course, was the minister in charge of justice in the Smith government. Mazimbamuta was detained under a state of emergency shortly before the Smith government announced this Unilateral Declaration of Independence, and it said that Rhodesia had become an independent sovereign state, and it proclaimed a brand new constitution, which let's refer to it as the UDI constitution, the Unilateral Declaration of Independence constitution. And that was supposed to replace the 1961 constitution, which we will call the old constitution. Well, under the old constitution, the state of emergency under which Mazimbamuta was being detained was due to automatically expire after 3 months. As the deadline approached, as it came closer, the government extended it and sought to maintain the detention of individuals who were detained under the previous emergency. Now, Mrs. Mazimbamuta brought a legal challenge on behalf of her husband and asked the court to declare that her husband's detention was illegal and also to ask for his release. Now, Mrs. Mazimbamuta's argument was that the action and laws made under the UDI constitution lacked legal validity in light of the existence of the old constitution, which the British had declared to still be the legal mandate. Now, this is where we're seeing the public law issue, and that the UDI was void and it was of no effect. The reality on the ground, however, was that for all intents and purposes, the Smith government retained effective control of the country, including, of course, the civil service and the security structures that were in place. Now, the case was significant because it was clear that what you were looking at here was a test of the legal authority and the legitimacy of the Smith regime, which on its side argued that it had successfully created a new order. And then you had to look on the other side of the illegitimacy of the tactics which were used and whether they were irrelevant because they were ineffective control. Now, the judges in the Rhodesian court were being asked to make a very difficult decision because it was one that was brought into focus a clash of certain political and legal allegiances. Now, as I said, it went through the various courts. It ended up at the Privy Council. And the Privy Council, of course, decided in favor of Mrs. Mazimbamuta in regards to her husband, and it reversed the decision of the High Court of Southern Rhodesia in that the 1965 UDI Constitution and therefore the Smith government were not valid since it had not been made by lawful means, and as such, the Smith government was not in fully effective control of Southern Rhodesia. Now, I want you to remember the point for the significance of conventions is that the court observed that there was a convention that the UK would not legislate for Rhodesia without the colony's consent. But given the case, we see this did not stop the UK government from, of course, legislating, arguably in breach of the convention, as it chose to do in that case. So when you talk about conventions and when you talk about the case of Mazimbamuta, think about when there is a breach in relation to that convention. Now, courts have been prepared to recognize the existence of conventions. So albeit that generally they will not deal with matters in relation to conventions, we do see their ability to quickly say, yes, it does exist. Case in point, of course, is Attorney General and Jonathan Cape in 1976. Now, in Jonathan Cape, there's an interesting discussion of the various conventions relating to cabinet secrecy, because the idea here is that everything done in cabinet and behind closed doors should not, of course, made public. So it was about cabinet secrecy, but the court could not enforce them, only the material law. The court could not say that, well, there is this convention and we are going to enforce it. What it had to look at was there some substantive legal issue? Was there, for example, a breach of confidence, which of course the court could decide on? Well, it was held that the publication of the Crossman Diaries, which was what was under consideration here, which included cabinet proceedings, was not in the public interest. That is what was being argued by the government. Now, the Attorney General, of course, sought to prevent publication on the grounds of a breach of a convention, and Lord Widgery, in his judgment, said that there is no obligation enforceable at law to prevent the publication of cabinet papers and proceedings, except where extreme cases involving, for example, national security is involved. The point here for our purposes, of course, it goes on and it looked at saying that, there was some other issue as to how long these proceedings had been and whether or not there was anything to be gained by PII. But for our purposes in relation to convention, what the court was saying is that it is not for us to enforce these non-legal rules. Now, when one also considers of re-amendment of the Constitution of Canada in 1982, this case was about the patriation of the Canadian Constitution in the early 1980s, and it illustrates the fact that courts will, of course, sometimes apply conventions even though they are not legally required to do so. And this was, of course, established in this case, and the fact was that under Canadian law, any amendments to the Constitution of Canada, an act was required from the UK Parliament. So we're looking at the Parliament's Act here. However, it was by convention that the Canadian Supreme Court should give prior notice to the provinces of any amendments in order to get their consent. So what you're looking at here is if there's going to be amendment, convention said you should at least do the courteous thing and seek to get some consent from the provinces. However, as this convention was recognized, it was subsequently ignored, and it was claimed that the Canada Act was invalid as the Canadian provinces did not give prior consent. Now, although there was no rule of law which required provincial consent to constitutional amendments, the question here was, did a convention actually exist? That is the point. And the courts were not constrained in finding that it could consider the matter as it related to determining whether or not they could intervene. So sometimes the courts will say no, other times they will say yes, but the idea and the point is that constitutional conventions tend not to be, or rather are not, legal rules. They are non-legal rules. So what are they? In a nutshell, as I say, Dicey referred to them as non-legal rules, and he went further to say, as we started off, understandings, their habits, though they may regulate the conduct of various, they are not laws per se. And again, I would draw your attention to what I consider one of the best books here is, of course, Hilaire Barnett, and to look at it for the way it sets it out. Now, Hood Phillips suggests that these are rules of political practice which are regarded as binding by those to whom they apply, but which are not laws as they are not enforced by the courts or by the House of Parliaments. And of course, I've raised in the previous segment what Jennings and Marshall say on the matter, and I would certainly ask you to refer back to that. So when you look at constitutional conventions, what I want you to consider is, what are they in practice? Let's consider some of the examples. Well, let's start by looking at conventions relating to the exercise of the royal prerogative and the working of cabinet system. Now, I would urge you to go back and make sure that you are somewhat comfortable and intimate with the royal prerogative, which is set out in a previous law session, and listen to it. Because once you know what the prerogative powers are, the question then is, what I'm considering here, what are certain conventions when we look at the exercise of the royal prerogative? Well, when we look at the royal prerogative, just by way of recap, it is about that special preeminence of the king, and which he has over all the subjects, and the residue of discretionary power, as it were. Well, when you look at prerogative powers, well, the convention is, as we say, the Queen will give the royal assent when, for example, there is an act which has gone through both houses. So if a statute has, or a bill has gone through both houses, then convention says that the monarch will give royal assent. The other thing is that when you look at a statute and a prerogative, then of course a statute will always trump a prerogative, because if the prerogative powers are such that the conventional rule is broken, so let's say, for example, the Queen decides, or the monarch decides, they're not going to give the royal assent, well, an act can be passed which then says how an act of Parliament will actually come into force. So where you get a breach, it may very well be, for example, in this context, when you look at the executive and the crown, it may very well be that when you look at the convention not being followed, the effect of the convention not being followed may be a statute coming into force. And as such, when you look at, for example, the control of the prerogative, there's a statutory control, and by way of case law, there's judicial control. We do see, for example, the case law, the Attorney General and the Kaiser's Royal Hotel case, that the courts are not reluctant to find that it can control prerogative powers if, for example, the convention attached to that is not followed. Statute prevails over prerogative and plays it into abeyance when we look at, for example, the Kaiser's case. In BBC and Johns, it says there should be no new prerogatives. And again, the ex parte Northumbria case, which has been raised, as well as the civil service case. All of these see what the prerogative powers are, and certainly how the prerogative will be exercised. It is the exercise of that prerogative power which is usually done in line with a convention. Now, there have been questions as to reform, and as such, I would certainly urge you to go back and look at the royal prerogative law session. But for our purposes, as it relates to a convention, the issue is, if there's a prerogative, you will carried out in accordance with the convention attached to that. We will take a short break, and as soon as we come back, we will then go into the next session of this law session.